Well, hello everybody and welcome to the Five Stone Building seminar, or webinar should I say, in this remote age, on mediation and other alternative dispute resolution methods in these strange times. Just a few points of housekeeping before we start. The first is that there is a Q&A button you'll see at the bottom of your screen. Please feel free to let us have any questions that you might have during the course of the webinar, and if we have time we'll try to get to those at the end. If any questions occur to you after the webinar, of course do feel free to contact us directly by email. We'd be delighted to answer any of those. We are actually recording the webinar today. If anyone is desperately bored, they can listen to it again or pass it on to any of their colleagues they think might be interested. But just to let you know that's happening. If you do ask a question but you would like to remain anonymous so that we don't identify you when we answer the question, then please let us know that is the case. So the Prime Minister's address to the nation last night, which some of you may still be trying to construe as to what it means, but I think what it really means is that this lockdown is not lifting anytime soon. And so therefore it is really important that the default is not putting everything on hold. And that we do go ahead and try to resolve our clients' disputes, relieve them of that additional anxiety. So without further ado, I don't need to introduce my two fellow speakers today. I'm sure they're well known to all of you. Can I say that we're going to start with Miranda Allardyce, who is going to look at some of the practical ways in which mediation can be set up remotely at the moment, and maybe for the future as well. We're then going to go on to Barbara, who's going to look at the difficulties of persuading clients to mediate remotely and some ways in which that can be overcome. And then I'm going to have a look at alternatives to mediation, how feasible it is to have early neutral evaluation and financial dispute resolution hearings dealt with remotely. So without more, I'm going to pass over to Miranda.
Well, good afternoon, everybody, and I hope that you are at the moment both, as it were, staying at home and will remain alert for the whole of this webinar. And so we hope to be able to look at some of the more practical elements to do with online mediation. And so, Joe, if I could just ask you to move to our first slide very briefly, echoing really Penny's concerns about the idea that otherwise, without resorting to remote mediation, one's going to be looking at very substantial delays, which are not going to assist in succession disputes, and with personal experience of trials being pushed over into 2021. So looking at the position that whilst this is going to remain relevant post-COVID-19, I'm just going to remind us of what we regard as it were, the magic features of mediation by looking at our next slide. So the purpose of this is really to see what we need to be replicating in our virtual environment. And the first of all is the aspect of all the parties being in one place and having, I would say, in otherwise busy diaries, an occasion when they are all concentrating on the settlement of a particular case. The mediator has to be able to gain the trust of the parties and engage in shuttle diplomacy, which was the phrase coined in respect of Henry Kissinger's moving between the Arab states and Israel in the 1973-74 war, but experiences that we all have of using, therefore, the shuttle diplomacy rather than the joint environment in which to be able to settle disputes, particularly in relation to estranged families. So looking now, if we may, Jo, at the next slide about how it is we achieve replicating those positions remotely. Well, the platform that seems to have been adopted wholeheartedly by mediators, and one which is used from business by adapting the concept of the breakout room, where people were having brainstorming sessions for resolving business dilemmas. We're going to be using exactly the same personal spaces for individual parties and their lawyers, where they can also achieve their own breakout room, despite the fact that the lawyer and the lay client may be many miles apart. So moving on, if we may, Jo, to the next slide, looking at these breakout rooms in a little more detail. In essence, they have the same criteria of being as a physical room, bricks and mortar provided by the breakout concept. It's the mediator who then is able to be face to face with the persons in the room. The mediator can be asked for help. Can the mediator please come in? And the only problem that we've identified, and it's one that's easy to overcome in essence, is that the mediator may rather disconcertingly suddenly arrive on your screen. And as we all know, that sometimes in the day the mediator is the least popular person in the whole building. And in those circumstances, you may be wanting a private discussion. And the reality is that they can announce their arrival, perhaps still by the use of email, a WhatsApp group, a telephone call, etc. But the important element to be able to tell the clients about is the concept of the privacy within the breakout rooms, so that none of the other parties are able to break that wall. So if we can move on to the next slide, if we may. And of course, one of the aspects that we know are problematic in mediations is the apprehension of the individuals that they are going to bump into, for example, the very estranged family member. And we'll all have had practical experiences of an uncomfortable start to the day when people have met in the lift or otherwise. And the great joy of this process, if it can be described as such in these difficult times, is that the creation of the pre-assigned rooms avoids any difficulty at the moment of people having to have, as it were, a face-to-face meeting on the screen. They're not going to be in a waiting room where they're going to see the other parties, for example, either a virtual or a physical one. So they immediately gain an element of safety in understanding the process. Of course, still, I think the reality is that we would all say that in many ways, particularly where you have got family members, couples, estranged, difficult previous relationships between step families, that the use of a joint session is currently perhaps more honoured in the breach than in the observance, save to the fact that the reality is that there may well be occasions when the mediator needs access to the lawyers. They need to be able to perhaps explain a particular point, whether it be of construction or whether it is to do with their perceived merits of their probate claim. And so that facility remains absolutely available to all the parties at any time of the day. So Jo, moving, if we then may, onto the next slide. What I think the important aspect always to think about is perhaps to make sure that we are keeping it simple, because the reality is that whilst there may be very exciting functions provided by Zoom 5, being the up-to-date version of Zoom that they have been working on now, very recently released, is that there are wonderful abilities whereby we can be looking at the chat facility. The chat facility, however, will be disabled for most of the mediation, because essentially what you absolutely want to make sure is, just as you don't want an exchange over the sandwiches in the corridor, nor do you want to see something offensive having found its way onto the chat facility. Now, the screen share, again, if one has a mediator who's very keen on using the equivalent, as it were, of the whiteboard, the important thing also is to make sure that between those rooms, there isn't, as it were, unorchestrated exchanging of screen share. And so the mediator would be the only one able to screen share. And it may be, for example, that there's a particularly useful document, which may be the estate accounts, maybe a particular will, maybe one particular aspect of the medical records that might be being used by one party or the other to demonstrate a particular point. But again, the important aspect being is that you have conferred that ability. The only person who has the ability is in fact the mediator. So no unauthorized interruptions. The recording facility, unlike today, where unfortunately none of us are thinking that this aspect of our screening facility, our recording facility, is going to be open to be downloaded, for example, by the National Theatre for a cultural exercise, the recording facility for a mediation will be disabled. And again, you'll have in the mediation agreement that nobody will in fact record. So if we can then look at our next aspect that we need to consider, I think this is partly really to reassure, perhaps in the light of the media aspect, that there were aspects that if you were inviting people to a public meeting, for example, I think as the church had been doing on a basis as it moved to Zoom type services, etc., and found people of other denominations disrupting the meeting, for example, that is a particularly different approach to our facility in providing this private confidential occasion. Personal invitation only from the mediator, link and password. If one's concerned, those can be sent separately, the link and the password. I think important also that you recognise at the first instance that it does not mean that your own individual parties have to give up their email. There won't be a group email. Essentially, the mediator can elect, having discussed matters with the parties, that they're just going to use the individual lay parties' email independently, and so again you don't have problems with estranged families finding that they are back in contact with a method of that undermining the mediation. The mediator importantly can see who is attending and can eject difficult individuals or somebody who should not have been there. They won't even be admitted in those circumstances, because in fact the permission is that you are asked whether or not you are going to admit a particular party. So essentially everybody who is not attended will not be allowed in. The gatecrasher of the evening of the daytime party will not be able to attend. The new facility with the 5 Zoom, which is helpful, I think, is that then the mediator, having identified everybody who is present, can lock the meeting. Of course, you're going to have the difficulty of the lay party being at home in their sitting room, bedroom, study, wherever. And one still has, in effect, even if you have a face-to-face mediation, you sometimes have the problem of who is attending, as it were, by telephone at inopportune moments of the day. So it's still a practical aspect that actually you need to have examined before the mediation about this issue of attendance. But I think it can be dealt with very clearly, again, with the old idea that if somebody who is attending in a supportive capacity, effectively they're going to need to have signed the confidentiality element of it. And the mediator, by reason of the camera, is going to have a fairly clear view of actually who is physically present in the room that they are communicating with. So having moved on from locking the meeting, perhaps we can then move to the next slide. I think the reality is that with all the aspects that we are grappling with now, be we Matt Hancock or be we mediators and lawyers who are now moving to the use of technology to move matters on and ensure that we are still being able to support our clients, is test, test, test. The preparation always having been key to a successful mediation. And I think the one thing that I would say is that actually the introduction of technology perhaps gives the mediator an extra opportunity to observe what might be difficulties within the day over and above that of the technology. Because I think the three of us would say that having, as it were, often our 48 hours before the mediation, if we're lucky, a conversation with the individual solicitors on either side as to any particular aspects of the case that they are concerned with. The reality is that we're going to get perhaps the 3D opportunity that we have hitherto not been able to take advantage of, perhaps several days, I would say, prior to the mediation, in which we will be introduced to the lay client. And one hopes that actually that will give the lay client an opportunity, in a sense, to identify any aspects that they are concerned about. And in particular, in conversations with the mediator will have been able to determine whether such matters that Barbara is going to be able to talk about are a real issue in terms of resistance to the mediation process, what particular aspects in terms of the historical past that they are worried about, for example. So I think it is actually, what I would say, is it going to give us an ability to have researched, I think, with a little greater distance from the hearing, any potential issues that we may be needing to iron out in advance, be they emotional or actually be they to do with the substantive law and the preparedness of everybody for the process. So can we then move on just to the next slide, if we may? Thank you, Joe. So the very basic tech requirements are effectively that the mediator's license, you'll be pleased to know, still allows them to run a 24-hour session with many participants. Not as many, we think, as today, as it were, because we're going to talk about the fact that actually, again, keeping the numbers down is an important aspect for it to be a successful mediation in terms of the numbers of parties. We're not looking to replicate the 24-hour marathon sessions because we think people do get tired. But again, what is useful is the idea that you're able to say, just as you're structuring your day practically, now is the time for a coffee break because I'm going to be spending half an hour in the other virtual room, and people are within the comfort of their own home. All the invitees, again, with the problems that we have, particularly with our age group in terms of lay parties, often you only need the basic Zoom. The technology download is actually relatively straightforward. And again, with those technical wizards in terms of the solicitors supporting us all, they will have been able to assist, we hope, the lay client in achieving this aspect. So again, testing the connection, relatively straightforward: laptop, desktop, iPad, tablet, preferable to a smartphone, although I know it can be achieved indeed by the smartphone. So looking, if we may, beyond the basic tech requirements now, just very briefly, Joe, to move to the next slide. So I think identifying aspects from the technology point of view that need to be thought about, it is that the lay client's camera and microphone work, and one can't actually overestimate the microphone aspect. It really does not assist if you've got one of the parties who actually is sounding like Donald Duck because their microphone isn't working, and it just leads to an enormous amount of stress. So those practical aspects of ensuring that the camera and the microphone have been enabled on the desktop element of the computer is very important. It also may be true that the lay client who's coping with either children at home or a disgruntled partner who isn't part of everything but who's taken the iPad charger is again not going to be a helpful feature because it does drain the battery quite considerably at some speed. And so one's going to want to know that you've got access to the charger, whether you're the professional or indeed the lay client. I think we just want to also indicate that it's jolly important for everybody to have this usual backup, the backup of the mobile phone numbers in the event of a hiatus. And again, they can usually be ironed out with some speed. Somebody might not have worked out how to unmute their microphone. Another suggestion, I think, from Penny, very helpful. She'd had experience of using a WhatsApp group and the mediator as a method of communicating, saying to the mediator, please, could you come back and help us now, or we're not going to need you for another 3/4 of an hour. So that timing element, very important. Sending documents again by email, not in the bundle, and or for the drafting. And just then, Joe, if we might finally just look at this issue of the attendees in terms of numbers and how we might grapple with that. So if you could move to the next slide. I think, again, one of the things we just wanted to say that I think, again, in order to develop that all-important relationship of trust and confidence, it is vital that the numbers are kept relatively modest, because the reality is that one is going to be trying to develop over the virtual Zoom platform, you're going to be needing to develop a relationship. And if you have got half a dozen people in the room, again, it's going to be so important. You're not going to probably want that many definitely in one room, and you are going to want the person who is the decision maker actually in central focus. And I think we're all aware of circumstances when we're having physical mediations, when we're finding that the lay client is buried within a phalanx of lawyers and supporters, and we as the mediators are trying to understand how that individual is under various pressures in order to make decisions. So works best, we would say, with a limited number of parties, so perhaps not to be too over optimistic that the 9 parties listed for the mediation that's gone out of my diary, that would not have been the one for us to be working on at this stage. One supporting lay party is then probably sufficient, be that spouse or friend, and again, present in the room. So finally, just if we could just have a quick look at the preparation in the outcome. So I think the other aspect, one's going to have to be thinking about an electronic bundle, maybe that's going to be printed or it's going to be a hard copy. I think one needs to also slightly be aware of how the client, let alone the lawyers, are going to be able to navigate what may have been several hundred pages of documents. So again, thinking about the actual reduction of a bundle to the 20 relevant medical records, for example, as opposed to 500 pages of the GP's records going back to the ingrowing toenail in 1959. So just important practical things to make this whole process a little more manageable. I think the other thing, it behoves us perhaps more to be prepared for settlement, drafting the here's one I did earlier, even if it's going to have to be worked upon. The facility is there for collaboration in the lawyer joint session, and again there'll be emails of draft as in the good olden days. One might be thinking about electronic signature. The other thing again one might be needing to think about is has the lay client therefore identified, however, that the lawyer is going to be able to sign any settlement on their behalf? Has the lawyer got their scanning facilities up and running? Does the lawyer have the electronic signature in place? So there we are. That is the very quickest of run-throughs as to the basics one might need in relation to technology. And I think the only thing finally in our final slide, Joe, that all of us really wanted to emphasize is that this is an era in which we are going to exchange discussions and ideas, and we're absolutely open for telephone calls, email inquiries as to whether or not there's a particular issue that needs to be ironed out as to whether or not this dispute has the prospect of being successfully mediated on Zoom. So thank you very much, everybody. And we're going to turn to Barbara, who's going to help us to overcome resistance to mediation.
Hello, everybody, and thank you for joining us. I'm going to talk about overcoming resistance to mediation. If I can have the next slide, Joe. And there are 2 basic themes I'm going to touch on. One is resistance to participating in mediation at all, and the other is resistance to reaching what is, after all, the objective of a successful mediation, which is a durable compromise. So taking those in turn, if I can have the next slide, all of us, and you in particular, because your contact with clients is more direct than ours, will have encountered resistance to participation in mediation long before we had to deal with the circumstances we're in now. And a corollary of resistance to participation in mediation is the penalties that the court can impose in terms of costs penalties for unreasonable refusal to participate. And I anticipate that's fairly familiar ground. To what extent has that shifted? Those rules are still in place. There is, of course, it's far too early to see any unspooling, as it were, and to see any test case of somebody unreasonably refusing to adapt to technology, to mediate by other means, as it were. Who knows whether we will see such a case? I hope not to be involved in one, not involved on the losing side, as it were. And I think all of us in our private and professional lives have undergone a great deal of processing of many uncertainties, many fears, and many adjustments, hour by hour, day by day. And one thing I'm conscious of, Miranda touched on it, is that in our client groups, amongst the likely participants in mediations in which we will be professionally involved are people in the shielding and vulnerable and extremely vulnerable categories, particularly those vulnerable just by reason of age. There are many over 70s actively involved in inheritance disputes. Indeed, I had a mediation booked in my diary in the first week of April that went out of my diary, and on inquiry there was precisely one participant who was in that category who could not contemplate participating in online mediation. Who knows to what extent that person may have adapted. I think one thing to be aware of, and we'll all have our own experiences and our own personal circles, is of the spectrum of adaptivity, and adaptivity over a time scale as well, that people who were fearful and resistant of using technology, because after all, Miranda's been talking about Zoom, and Zoom has established a degree of dominance. It was primarily designed for business meetings. It's highly adaptive to the particular type of business meeting that a mediation is, but it's been very, very widely used socially as well by people to keep in touch with shielded members or distant members of their families. There are Zoom drinks parties, Zoom dinners. So there is a strong possibility that somebody who was resistant to technologically assisted participation in a business meeting, in a mediation 8 weeks ago, may have overcome that resistance now. And I think it's a thing to be aware of, again, is that spectrum of adaptivity. I was thinking about the case of Skull against Skull last year, which was the case about which of a couple had predeceased the other when they were both found dead in circumstances uncertain, what the order of deaths was. It's not a very ill-informed comment about that case, but the relevant point for today that comes out of it is that Mr. and Mrs. Skull lived in a bungalow in quite a busy suburban road. They weren't in any way isolated, even with today's spin on isolation. They're very closely connected with their neighbourhood. They each had adult daughters from previous marriages who they were in contact with. Their contact was a landline. They had no mobile phones. There's no evidence that they used WhatsApp or even on any other device. They stayed in touch by making calls on a landline, as people of that generation did habitually until all these new things were invented. So there's going to be a spectrum with people like that one end of it, and then people who are already highly adaptive and familiar with using tech at the other. And one of the other things that's been very much in my mind is thinking back to the very start of my career. In fact, before I became a barrister in the early 80s, I worked in the tech industry. I had an English literature degree. I had no technical skills at all, but I had to learn because my job was to explain in writing and user manuals how to use software programs to people who were, effectively, they were a virgin population for that. It was an era in which computing, operating computers, writing software, working with software, had been entirely the preserve of the technically skilled in computer suites, which were locked away from everyone else. With the advent of the personal computer and the desktop, that all changed. And so people doing entirely different kinds of jobs, from business proprietors and executives to the school leaver clerical assistant, all had to learn. They had to adapt to learning and using software. There was a great deal, as unimaginably less user-friendly than today's software. There's no graphics, icons, anything like that. And so it is possible for everyone who is capable of participating in a discussion about compromise of a legal dispute that they have capacity to conduct is, I believe, capable of mastering the technology in order to participate online. I think that's sort of worth keeping in mind. And two strands of persuasion are, one, that there are positive benefits, and I think collectively we'll all touch on those, the fact of not having to leave your own home, of being in a more comfortable setting and a more familiar setting is one of them. There are cost implications as well, because you can take everyone's travel costs out of the final bill. And also, in all the known unknowns and the unknown unknowns, as Penny mentioned, this is not going to come to an end anytime soon. And of course, what happens in the world of mediation is not dissociated from what is happening in the world of courts, because mediation only happens in the shadow of active litigation anyway. And I'll say a bit more about that in a moment. It is likely that the use of technology in hearings, there's a great deal of debate and discussion and research going on into that, and there's been a huge sort of leap into it. A lot of that is likely to be here to stay, and I suspect with more positive participation in remote mediation, a lot of it will be here to stay as well. So I think that's sort of setting the scene about remote participation. Can I have the next slide, please, Jo? About remote compromise, I think there are three sources of authority, as it were, which need to be checked pretty regularly to keep a finger on the pulse of what's going on. And one of those is HMCTS publish every week a weekly update covering everything that the court service does, of what's what and where's where and what priorities they have. Unsurprisingly, the kind of work in which we specialise, succession disputes, is not on the priority list. You wouldn't expect it to be, but it is important to check that to get some sense of where the court's structural efforts are focused. That's one thing. The other is the civil procedure rules and practice directions, and in particular, the new practice directions out in PD 51 dealing with extensions of time, sanctions. Basically, I see it as rather analogous to, in London we've had the congestion charge zone suspended and the low emission zone suspended, all sorts of regimes of compliance with good civic behaviour have been suspended for emergency reasons. And there's a little bit of a parallel on the civil procedurals, but again, it's important to be on top of that. If you're already in active litigation, you need to know what deadlines are real and what deadlines now have some default built-in flexibility in them. And then the third leg, of course, is the law of limitation. And where we are with, and I've mentioned particularly 75 Act claims because by contrast with contentious probate disputes, where, as we know, there is no fixed limitation period, Inheritance Act claims, which are very, very significant in my mediation practice, do have a short primary time limit, and that primary time limit has not been suspended. So for many people, advising clients on bringing or defending prospective Inheritance Act claims, you're working against a background of a short limitation period, but potentially a pretty protracted disposal period for litigation, with a lot of relaxation of what's really at the heart of the civil procedure rules, which is the active case management and sanctions for non-compliance with active case management. So I feel that's sort of setting the scene of the world that we're in. And I've certainly I had an Inheritance Act trial in my diary last week, which has been adjourned to next March, and I take that as a kind of template. I mean, in that case, both sides consented to adjournment. My client, although UK national, doesn't live in the UK, and they would have had very great difficulty travelling to the UK, difficulties of remote participation. Certainly the adjournment was granted without further ado. So I think that is the setting, and I've already mentioned being aware that there may come a time of interrogation about if there's a refusal to participate in mediation and a case goes to final disposal, there may be an interrogation about the reasonableness of the refusal to participate and the potential consequences of that. Could I have the next slide, please? And then, assuming all this resistance has been overcome, and you have your parties and your mediator in their virtual rooms, and everything is working possibly can, are constructive. I think it is very much a feature of the kind of work we do, or certainly the kind of work I do, and again, going back to Inheritance Act claims, that at least one significant property transaction is at the heart of them. A cohabitee is persuaded to move out of the formerly cohabited home and to move elsewhere, and there are terms and conditions about the transfer and the distribution of the proceeds and the adjustment of interests in the estate. Clearly at present, and we're in a slight limbo period where we've had the Prime Ministerial speech, had various ministers on the radio this morning, but the law has not changed, the regulations have not changed. In that limbo period, the status quo is really that property transactions are frozen. And of course, many of the property transactions we'll be concerned with will be residential properties. I was an advocate at Mediator, where as part of the settlement agreed, there was to be a disposal of some commercial property, and with a long stop, that disposal fell through in March this year. And so that leaves the parties in an utterly unforeseen and not entirely attractive situation. So these are really significant practical difficulties to work around. It is not going to be possible to get any certainty. I mean, there are two aspects to valuation uncertainty. One is lack of access for valuers to the subject property, can't actually physically go round. So everything they say is going to be qualified by that lack of physical access. And then nobody knows how, even when it comes that transactions are unfrozen, what impacts there will be on value and when. And these are, I see these as real, genuine obstacles to reaching a compromise. And my only suggestion for seeking to overcome them is to be creative and to be flexible in building in time periods and alternatives into terms of resolution, and ensuring, for example, that say there is an agreement that property be disposed of and there's a sort of target valuation, that if the parties can be persuaded to agree that if the valuation falls below a certain percentage of that target, then the parties may renegotiate. There's some escape clause. I mean, obviously as a mediator, it's not for you to impose terms. These are really the things that for the parties to think about. I see these as really serious questions, but I don't see them as entirely insuperable, because I think the need to get on and work towards resolution of disputes is the dominant one. And the final point I've mentioned on this slide, political age in this country are in a highly variable set of circumstances. There are many, particularly public sector employees, people in key worker jobs, who are being paid their salaries and working really hard. There are those who've been furloughed. We don't know how long the furlough scheme is going on. There's talk of it going down to 60%. There are other people, business proprietors, many self-employed people, who have access to the government's scheme because their earnings are too high, may feel that, yes, they're fortunate to an extent, but they may still feel their circumstances are very precarious. You don't have to be much above that threshold and perhaps have quite large financial commitments due to a family or a mortgage or so on to feel pretty precarious. And we all know, I mean, particularly with Inheritance Act claims, where you're putting people's budgets under a fairly microscopic focus, claimants' budgets in particular, what defendants, a real issue for defendants to grapple with is, what if the claimant who has presented their position now and their foreseeable future, if their foreseeable future is significantly adverse compared to what it is now, if it's likely to be significantly adverse, then that's something that has to be factored in. And there's an incentive to defendants to take their own view of that adversity and seek to reach a durable agreement adversity deepens. And that sounds like a careless way of putting it, but you know, each of us as advisors and advocates, we have clients' interest to defend, inevitably at the expense of somebody else's interests. It's trying to reach an accommodation between those conflicting interests. That's the whole purpose of mediation. So that's really all I wanted to say. Thank you. It's a rather superficial tour, but they're all points which I hope will be useful to reflect on as things develop. Thanks very much.
Well, hello everybody. I wanted to move now to some alternatives to mediation, which might be considered in the light of the current prevailing circumstances. And Joe, if we could move on to the next slide. There are two main alternatives which are worth considering if either mediation doesn't work, or alternatively, there is some issue, or a mediation, perhaps remote or otherwise, may have failed. So the first of these is early neutral evaluation, and the second is financial dispute resolution. And I'll come on to talk about the differences and how they might play in the current prevailing circumstances. But there is certainly scope for dealing with both remotely, and indeed they may work very well in the current circumstances. So if we can move on to the next of the slides. So the differences between early neutral evaluation and financial dispute resolution. Early neutral evaluation is where a court or other entity provides a view as to the likely outcome of a case, and it's particularly suited to cases where there might be some point of law. So for example, if you have a will with a difficult point of construction, or perhaps you have a 1975 Act claim where there are issues as to whether or not the court might vary a trust. Now, strictly speaking, early neutral evaluation doesn't involve the court in supervising any negotiations between the parties. It simply involves the court in expressing a view as to the question that is being put to it. But in fact, there is quite a lot of crossover, or one might even say confusion, as to the difference between early neutral evaluation and financial dispute resolution. In financial dispute resolution, the judge not only gives a view as to how the case is likely to go, but also supervises the negotiations. And it comes, of course, from the divorce jurisdiction, where it's been used very successfully for many years in relation to the financial relief granted after a divorce. But it's become very much the norm in 1975 Act cases. If we can move to the next slide. Early neutral evaluation, it was established in the Lomax and Lomax case that was heard in the Court of Appeal last year, that the court can order it as a compulsory measure. Now, this is interesting in the current circumstances. In the Lomax case, there was considerable resistance by one party to having an early neutral evaluation. But the court said that it could be ordered under CPR 3.2M. Now, that being the case, it does occur to me that there are circumstances currently where the court will order early neutral evaluation if asked to do so, and possibly of its own volition, because it may well be that that is a way of getting a view which might assist in resolving the parties' difficulties. If we can have the next slide, please. So how might early neutral evaluation work? Well, one of the great advantages is that many early neutral evaluations take place as a paper exercise. And assuming that the court is involved, quite often the master or judge will be asked to give an opinion about a particular legal question, and will be asked to do so in writing. So there's absolutely no reason why that can't go ahead, as was happening beforehand. Generally, it will be without prejudice and non-binding, but of course the parties can decide that they would like something different, so they can ask for it to be a binding indication, and they will then negotiate on the basis of it. So for example, if you had a question of some doubt about the construction of a will, you could actually ask the court to decide that on paper for you, and then conduct your negotiations accordingly. So it can be held before a master or a judge, or the application could go before a master or a judge. And in general, you have to make out quite a case to have a judge give an indication. However, what does appear to be the case at the moment is that certainly judges of the business and property courts are more available than masters. Masters are holding 5 or 6 hearings a day on average, virtually, whereas the judges are doing far fewer because, as Barbara indicated earlier, a lot of cases are really going off and not being heard until next year. So it is worth perhaps indicating that a judge could give some sort of indication. It's possible to have private early neutral evaluations. In fact, they've been something that's been going on for years. So to pick somebody who is an expert in the field to give an indication on a point of law, and of course the parties can agree that they will be bound by the outcome of a question that they ask that person. Now, it's fair to say that while many early neutral evaluations are conducted as a paper exercise, sometimes they look far more like an FDR. And in fact, that's what happened in the Lomax case, where there was a hearing ordered in front of a High Court judge, and the hearing took place almost as if it was an FDR. And indeed, the judge descended into the arena and supervised the negotiations between the parties, even though it was indicated to him that it wasn't really his job to do so. But in general, the early neutral evaluation will end at the indication being given. Can I have the next slide, please? So financial dispute resolution hearings are somewhat different. They are ordered by default in the family division. So if a 75 Act case is going ahead in the family division, then an FDR will be ordered, and a case has to be made out for it not to be ordered. And there is nothing to suggest that the current prevailing situation is altering that. FDRs are still being ordered. They will be in front of a High Court judge in big money cases, but in general will be conducted by the district judges in lower value cases. It's rather different in the business and property courts, the property trusts and probate list. I've called it the Chancery division on this slide, as it sort of rather trips off the tongue rather better than that. The parties have to agree to an FDR, it can't be ordered. And it's almost always conducted out of London by masters and district judges. It's become the norm. It's less frequently dealt with by the masters in London, but it's becoming more frequent. And it's particularly well suited to 1975 Act, Talata, partnership and 994 claims. Now, there is absolutely no reason why an FDR cannot be conducted remotely. And in fact, particularly the Zoom application, which unfortunately a lot of the judges are not using. The Zoom application is particularly well suited because, as with mediation, as Miranda has explained, there are breakout rooms. And so when the judge is not giving an indication to the parties, then it is possible the parties can disappear to their breakout rooms to negotiate, to discuss, and all the various practical matters that apply in a mediation that Miranda has spoken about apply also in relation to the FDR. Can I have the next slide, please, Jo? All the things that normally apply in relation to an FDR will apply remotely. So it's not a mini trial. Position papers shouldn't be skeleton arguments, but should give a history as to the sort of negotiations that have taken place. And the judge will supervise the negotiation. So again, the Zoom application, and I understand that the family High Court judges are very happy to conduct hearings by Zoom, particularly FDRs. The judge is able to supervise the negotiation. You can go back into court by communicating with the judge, and you can have discussions with your own side in a breakout room. Next slide, please, Jo. I've touched upon the fact that the courts seem to be somewhat wedded to Skype for Business at the moment, which is not particularly well suited to having an FDR, but I understand that they are moving over to Microsoft Teams quite soon, and hopefully that will assist. And a lot of the judges, as I've said, are happy to use the Zoom application. The reason why FDR works so well is because you're getting a hearing by one of the judges who is a judge who hears these sort of claims all the time, and so their view is taken seriously, and it can be a very, very good way of ensuring that your client knows that this is a likely outcome, and a likely outcome that has been predicted by the sort of person who's going to hear the claim at the end of the day. Next slide, please, Jo. But there are some advantages in having a private FTR, and they have become increasingly popular. First of all, and this is an important practical point at the moment, the family division judges are absolutely overwhelmed dealing with urgent applications and dealing with them remotely. And so it can be quite difficult to get a date for an FDR that's taking place before the court. And there could be reasons why it's very important that the matter is heard fairly urgently. For example, you may have an elderly client bringing a 1975 Act claim and not have to wait. You can use whatever software platform suits the parties. And an FDR in front of a silk or a senior junior who practices in this area can be just as helpful as one by a judge. And obviously, if you've got somebody who sits as a deputy judge, that can also give some confidence in the parties that, again, this is a hearing that's taking place in front of somebody who is likely to be the arbiter at the end of the day. And the important thing also about having a private FDR is if you have an FDR in front of a full-time judge, then that conflicts the judge out of hearing the matter at the end of the day. Whereas if you have a private FDR in front of somebody who isn't likely to be the judge, you don't have that problem of conflicting out. So that's all I wanted to say. We've had a couple of questions in during the course of the seminar, and we've got a few minutes left just to deal with those. The first, which is a very good question, is and one for Miranda, I think. In the face-to-face scenario, it's possible to see the body language, but it's not when you're using Zoom. Miranda, what do you think about that?
Unmute. I think the interesting thing about that is that in some ways, actually, because the person with whom you are communicating is center stage in terms of the camera and your exchanges with them, sometimes actually I think that you can you have as good an opportunity to observe body language. I think the important thing always remains communication, and also perhaps the parties supported by their lawyers must be prepared to be absolutely blunt with the mediator about whether or not they are feeling that there's a particular aspect which isn't working for them. They're worried somebody's spending too much time in another room, too little time in theirs, they're not being listened to. I think it's part of our duty to sort of facilitate the lay clients explaining what they are finding difficult about the process. So I think one just has to be on alert and really to ask the lawyers representing their client also to indicate if there is an aspect that their party is finding particularly difficult, and so that we are aware that there is something that needs to be addressed, which is something one faces in a face-to-face mediation in any event.
And Barbara, there's a question as well for you, which would you, given the difficulties in assessing asset values and the potential precarious nature of the financial circumstances of the claimant in time of COVID, is there not an argument for trying to return to written negotiations through Calderback and Part 36? Could there be adverse cost orders for refusing to mediate, citing the difficulties above, but in circumstances where proper efforts have nonetheless been made to settle through intersolicitor communications? What do you think about that, Barbara?
Oh, I think, and hello to Amanda, it's an excellent point and absolutely worth underscoring. I never see mediation as being exclusive of written negotiations. I mean, the mediations, just flipping through my mental Rolodex of mediations, the many mediations I've been involved in, there always has been some antecedent, and there's certainly been, at the very least, pre-action correspondence and perhaps some absurd absolutist position being taken in negotiation. But I would say that is the exception. Far more likely to see a pretty well-developed set of negotiating positions being taken, but the gap not having been closed. And I think, yes, these reasoned written exchanges are still going to be at the heart of things. And I mean, it would be lying to say I'd given anything other than very superficial thought to thinking ahead to the possibility of somebody running an argument about an unreasonable failure to engage in mediation because of unwillingness to participate in remote mediation. I am currently giving a tiny bit more conscious thought. I would have thought a judge would be very, very reluctant to impose that sort of penalty. It would look pretty hard. Would have to be very satisfied there had been something egregiously unreasonable in the conduct before imposing that sort of penalty. And I absolutely agree that a degree of a realistic, meaningful, constructive engagement in any sort of process likely to bring a dispute to an end ought to be an answer to that.
I couldn't agree with that more. I think that those sort of arguments are not going to play where it's possible to say, look, it made no sense to mediate because of uncertainty at this time and practical difficulties. I think those arguments are going to be much harder to run. The final question we had was about success rates. I think my view on that is it's far too early to tell. There's been something of a pause, I think, in mediations. A lot of, I think I had 4 or 5 go out of the diary right at the very beginning. I think it's quite important that we get our clients to start thinking about it again. But I think at the moment, it's impossible to say. Anecdotal evidence from those who've done a few are that the success rate is about the same as one would expect, that actually mediations do tend to be quite successful, and remote ones are as successful as face-to-face. But I think we need a bit of time before we can really come to any conclusions on that.
Can I just interject there, which is that something I found recently with face-to-face mediations, I had 2 or 3 which were very close to a compromise at the point of physical exhaustion, need to escape from being held to ransom in a biscuit factory, that whole atmosphere of the face-to-face mediation, and which then very satisfactorily settled through telephone shuttling within a week or 2 later. And one thing I envisage with remote mediation, everyone says of their experience of doing serious, fully engaged professional legal work with other people remotely, that it's tiring. I think that's no less true of mediations than it is of court hearings. And certainly with court hearings, they're putting breaks in. And I think we need to be realistic about what might be achievable within the hours of concentration engagement that collectively everyone there has to give, but also recognise that it's going to be easier to suggest and to complete the follow-on, just to set up another Zoom meeting for the following day or 2 days later when people have had time to think about things. So it's going to be a continuity of the same experience. And I would have reasonable confidence in that working, just as it has done similarly, telephone diplomacy following on a face-to-face mediation.
Well, I think we've probably run out of time there, and thank you very much to everyone who's joined us. I note we've got a few more questions in. We'll happily deal with those afterwards. And I note that somebody's got an FDR next week. Really interested to hear how that goes. So do contact us if anyone has any further queries or wants to discuss the possibilities of remote mediations, FDR and ENE, and enjoy the rest of your day, everybody.
Thanks, everyone. Bye.
Bye-bye.
Bye, thank you.